Arthur. Hello, sir. May I have your full name and your date of birth, please?
Obed Signs.
Thank you, Mr. Signs. You're here in a new case. You were arrested for possession of narcotic drugs, both for sale and as simple possession. That's a Class 2 and a Class 4 felony. Also, drug paraphernalia possession, Class 6 felony. There is probable cause for all of those things, and I am appointing a lawyer for you. Your next court date is a status conference November 4th at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing November 6th at 8:30 in the same court. And on these facts and this alleged quantity of drugs, I'm going to put you on an ankle monitor with drug and alcohol testing. I believe the state recommended a $5,000 bond. That's not unreasonable for drug dealers who are local. Drug dealers who are not local or who go above a certain amount or a certain criminal history, it's cash bond every time. But if you did these things, you're just getting started as a drug dealer. So I think an ankle monitor is enough right now. If you don't follow conditions, if you can't follow conditions, you're already above a statutory threshold for mandatory prison if you're convicted on the sale count. Talk to your lawyer about this. That being said, you really don't have much criminal history. That's why I'm putting you on an ankle monitor, because essentially for most of us here, you're a baby. You're not even 21. But if you want to be your age in the state penitentiary, which I don't recommend, I really don't recommend, you will not come out the same person you go in. You need to comply. You need to comply. I don't want you to take this lightly. You're already over the threshold. Still, on my standards, you're small time. Doesn't mean you won't go to prison if you lose at trial, but you may well get a probation offer. The county attorney is the one who's going to decide whether they give you a probation offer, because if they decide to go to trial and they win, you're above the threshold. You're going to go to prison. I hope you can do math, Mr. Science. I hope you can, because your life is at a crossroads right now. You know, behave accordingly. If you want this to be your life, screw up. We'll see you back here. If this is what you're up to, you will not avoid police notice for very long at all. At least you didn't have a weapon. If you had a weapon, you'd be getting a bond right now. Step to your left, and by the way, it probably wouldn't have been secured. If you had a weapon, I'd be looking at 15 to 25. So step to your left, take your paperwork. Good luck, sir.
Thank you.
Mr. Webley and Katie Mitchell, we go to the chair. Hi, sir. Can I have your full name and your date of birth?
Seth Larry Webley.
What's your date of birth?
3.
Thanks. Mr. Webley, you're here on some misdemeanor warrants and also a felony warrant that is actually fairly old right now. You've been charged in a criminal complaint with 2 counts of aggravated DUI. Those are Class 4 felonies back on June 9th of 2021. This warrant was issued just a little over 2 years ago now, and this comes out of the Gilbert Police Department. So you'll get police reports and a copy of the charges from your lawyer. I am appointing a lawyer for you. Your next court date is a status conference November 4th at 8:30 in the morning, which is 2 weeks from Monday, November 4th, 8:30. Preliminary hearing will be November 6th at 8:30 in the same court. And you've not missed any court dates in this case. There was an attempt made to send you a summons, but it came back undelivered. So you've not missed any court dates. This is a new case from our perspective, even though it's 3 years ago. So I'm going to release you to pretrial services with drug and alcohol testing. I know about your prison record, but this is a new case. And 3 years ago, you know, there was an attempt made to summons you. So
Thank you.
You're going to go to pretrial drug and alcohol testing. Now, you're also here on driving on suspended warrants. Hang on a second. So one from Hassayampa, one from Santan, one from West Mesa. So there've been a lot of courts looking for you for various misdemeanors since about 2021 and 2022. They are failure to pay warrants. Let me double check. 2 are failure to pay. They are all failure to pay warrants. They're not failure to appear. And there is a big difference to us at this jail about that. Failure to appear, we absolutely treat differently than failure to pay. So I'm going to release you on your own recognizance. Go and talk to them. If you don't, that's a failure to appear, and we care more. So you got different court dates. Some of them might overlap. You may have to make some calls. So I'm going to start with Hassayampa. We're going to go. That's number 6 on the calendar. It's drug paraphernalia possession. It's Class 1 misdemeanor. You've already been convicted. Your court date is Wednesday, November 6th, 9 in the morning. That's up in Surprise. That address will be on your paperwork. Number 5 on the calendar is the Santan Justice Court down in Chandler. This is a public nuisance conviction, also a misdemeanor. Your court date there is November 5 at 9 in the morning. So it looks like so far we're okay on overlapping court dates because your Superior Court date is the 4th. Then West Mesa, okay, here's one that's a problem. West Mesa Justice Court, driving unsuspended, November 5th is your court date. So West Mesa is the same time as Santan. And so you need to pick one of those courts and call them.
Okay.
And ask to have your court date moved, okay? Mr. Webley, you got 2 weeks to do that, all right?
I'll make sure to get a hold of them.
All right. I hope you do. I'm glad. I don't know what you've been up to, but you have not been arrested in a couple of years at least. So that's a good thing.
I've just been working.
Good. All right. Because right now you look a little rough, I got to tell you. And you have been to prison even at your young age and not for nice things. So I hope that you understand if you don't want to go back to prison, you need to look like a good candidate for probation in that DUI case.
Is probation available in the DUI?
If they offer it.
I thought...
They have to offer it.
I thought it was a mandatory prison term.
There is one. It is 4 months. You're absolutely right. On a Class 4 DUI, there is a mandatory minimum before you get probation, and it is 4 months at DOC. That's very true. But for a lengthy probation sentence, the county would have to offer that to you. So talk to your lawyer, because, no, it's true. With your priors, if you go to trial and lose, you're in Category 3, as they call it, which is the highest sentencing range. So if you go to trial and lose, as I understand it, I'm not your lawyer, as I understand your priors, you would be sentenced in Category 3, and that is a 10-year presumptive, unless it gets mitigated, et cetera, et cetera, et cetera. So talk to your lawyer. Your lawyer will help you calculate all of that, but it would, probation remains within the realm of possibility, but you're absolutely right that in an ag DUI case, the price of probation is 4 months at DOC first. So talk to your lawyer about outcomes. I gave you a lawyer. If you don't show up, you are basically looking at worsening your outcome because the county attorney is not going to think you're a good candidate for a better offer if you never show up.
Okay.
Step to your left, take your paperwork. Good luck, sir.
Thank you.
All right, Ms. Mitchell, Katie Mitchell, and then Trenton Bush. We go to the chair. Hi, ma'am. Can I have your full name and date of birth, please?
Katie Elizabeth Mitchell.
All right, thank you. You are here on a new case. You got booked in for assault and disorderly conduct. Those are Class 1 misdemeanors. There is probable cause for them, and I am appointing a lawyer for you. You'll meet that person at your next court date, which is going to be on November 6th. That is almost 3 weeks from now, November 6th, 9 in the morning, in the Hassayampa Justice Court, and I think that's in Surprise. The address is on your paperwork. And I'm going to release you on your own recognizance. You have some domestic violence type release conditions. You can't have any contact with the alleged victim or live where he lives. I know you have a kid. Is that his kid also?
No.
Okay. All right. So I'm not specific, because you really don't have much in the way of criminal history, if any, as I recall. Not much. I think you have a little. I'm not going to specifically order you not to live there. I'm just ordering you not to live with him. Don't have contact with him. Right. I see in July of 2021, you got arrested for some DB stuff, but it looks like you did not take a conviction for that. So I was trying to leave open the possibility that he goes and you stay, but you can't call him and tell him to do that. If that, I don't know what people's living situation is. I just don't want to lock you into something. Like if he's willing to go and he goes, you could be there. But if he's there and he wants to stay there, you have to find an alternative residence. You can do a civil standby with law enforcement, which would be the sheriff's, it looks like. They'll send a deputy, keep the peace while you collect some stuff. No weapons, no drugs, no alcohol. If you get served with an order of protection, you have to comply with that as well. But I'm releasing you. Do your best to comply with these conditions and don't get yourself arrested. Show up on November 6th, okay? All right, if you take your paperwork, you'll be all done. Good luck.
Thank you.
Mr. Bush, and then Mark Espinosa. Will you please go to the chair? Hello, sir. Can I have your full name and your date of birth, please?
Trenton Bush,
Thank you. You're hearing a new case. You were arrested for trafficking in stolen property in the second degree. It is a Class 6 felony. There is definitely probable cause for it, and I am appointing a lawyer for you. Your status conference is November 4th at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing November 6th at 8:30 in the same court. State recommended a $25,000 secured appearance bond for you. I know exactly why they did that. I'm not saying that I'm doing that, so just wait, okay? I'm not inviting you to talk right now. What I'm saying is there appears to be a very strong weight of evidence against you. Likely, many offenses. You could be facing far more than what is currently alleged against you. They've alleged exactly one thing against you. It is a property crime. You appear to have some ties to Arizona, but you also have priors. They are somewhat old drug priors out of California,
Yes, ma'am.
and a petty theft, 2003. So you are not without criminal history, and I don't want you to think that this court thinks there's not pretty serious weight of evidence against you in this case. Once you see it, the police have been investigating you. This is not a one-off. So, your wife got released apparently, or wife, girlfriend, whoever it is, your co-defendant, I shall call her. She got released to pretrial services. Your risk assessment comes up OR, meaning they calculate that you're likely to appear and you're not likely to commit new crimes while the case is pending. Those two things are not the same as likely to be convicted and suffer a term of incarceration, which right now you have what I like to call a very bad problem. There's a heavy weight of evidence against you on a lot more crimes than this, similar. Looks like it says wife and 4 children. You come up OR, it's a property crime. So I am going to release you. I'm not going to bother to make you report to pretrial because I don't think that's going to make the community any more safe. What I'm telling you, Mr. Bush, is I'm trying to give you a clue so that you will comply with conditions and come to court.
Thank you, sir.
You have a serious problem, and so does your wife.
Yes, ma'am.
If you don't come to court, if you commit a new offense, you'll be held without bond on it. Look up the statute. I put it in your case. If you come in on a new case committed after today, and it's a felony, we're going to hold you without bond.
Thank you.
So, anything else that might be going on, you critically must appear for your hearings, comply with your conditions, categorically no contact with the alleged victims, and you may not access the internet for any reason other than work and your children's school purposes. I don't know if your wife got the same order, but you two should grow a clue about the traceability of things that happen on the internet. They are alleging a long list of evidentiary items against you. So what did you want to say? Because I recommend you don't talk about your case, Mr. Bush. If you go to trial and lose, you are looking at prison.
I'm being OR'd though.
I'm ORing you. The reason for the lecture, Mr. Bush, is because I'm releasing you.
Yes, thank you.
I don't bother to lecture people I give a $100,000 bond to. Why would I bother? I'm releasing you. I'm trying to get you to succeed pre-trial. Success prior to trial. Showing up for court, complying with release conditions. That's the test.
Okay.
Number 1 release condition is do not commit new crimes. Number 2 is absolutely no contact with the alleged victims.
Okay.
So, if you screw up, Mr. Bush, then I don't care what, algorithms tell me. Then I don't care. You're getting a bond.
Thank you.
So, comply with your conditions. Talk to your lawyer. If you flee the jurisdiction, we will extradite you.
Yes.
Apart from that, it's a struggle to release people when you dislike the offense conduct so badly. But it is not correct, it's not legally correct for a court to set bail based on how much they dislike what someone's accused of. Because to quote a very respected person in our system, then no one would ever leave the jail. So I'm doing this on objective reasons, objective facts. If it were based on what's been alleged against you, I would absolutely set at least a $25,000 bond, because what's alleged against you, if you did it, is pretty scummy.
Okay.
And it's the kind of thing that people can get away with for a long time, right up until the train pulls into the station, loaded with evidence against them. So I think your train's in the station, Mr. Bush. Grow a clue. Don't screw up. To me, screwing up is committing new crimes, violating your court dates, missing your court date.
Okay.
Right now, you are presumed innocent. I've not forgotten that. You are presumed innocent.
Yes, ma'am.
Don't throw that away
Thank you.
by
So-
not showing up.
Okay.
Step to your left, get your paperwork.
I'll go home.
Mr. Espinosa? Oh, and then Mr. Johnson, you go back to the chair. Right here, sir. Oh, hang on, you know what, I was waiting for pretrial to do something in your case, hold on. Let's see if they did it. Yes, okay. 1 second, okay? I forgot. Okay. All right, let me have your full name and your date of birth.
Mark Espinosa.
Thanks, Mr. Espinosa. You are here on a new case and 2 warrants. One from the Encanto Justice Court, one from the El Centro Justice Court. In the new case, you've been accused of possessing narcotic drugs, a Class 4 felony, 3 allegations of possessing dangerous drugs, Class 4 felonies, 1 allegation of failure to admit the carrying of a deadly weapon in a vehicle when asked by a police officer, and open container of alcohol in a vehicle. Those are both misdemeanors. There's probable cause for all of that, and I am appointing a lawyer for you. Your next court date is the status conference, October 24th. That's this Thursday at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing October 28th at 8:30 in the same court. You're also here on failure to appear warrants in justice court cases. In the Encanto Justice Court, you've been charged with driving on a suspended license and failing to appear in a misdemeanor case. Both of those are misdemeanors. Your arraignment hearing in Encanto Justice Court is scheduled for this Wednesday, October 23rd at 8:30 in the morning. In the El Centro Justice Court, you have been charged with the same 2 crimes, driving on a suspended license and failing to appear in a misdemeanor case. Those are both misdemeanors.
I just didn't know I was supposed to appear somewhere. That's all.
Your arraignment hearing will be October 23rd at 8:30 in the morning in the El Centro Justice Court. Your bonds are as follows. In the new case, $2,500 secured. I'm affirming the bonds out of the Justice Court cases. $750 secured in El Centro, $500 secured in Encanto. So whatever that total is, it's on the order pushing $4,000. It is secured. And so, Mr. Espinosa, I've looked at your case card. I don't believe you that you didn't know you were supposed to go. You also have a suspended license for DUI. You were caught yesterday with a panoply of drugs that I would bet you, so the smell of dealing on you, and a gun. You don't have the right to drive. You don't have the right to do drugs and drink and drive. You don't have a valid license. There is a demonstrable danger that you pose to the community, absolutely, and you've demonstrated that you will not voluntarily appear. That is why you're getting bonds in all of these cases. If you post them, comply with your conditions, you'll have a lawyer in the misdemeanor cases to help you with the bond issue only. Once you no longer have a bond, you don't have a lawyer in the misdemeanors. I did appoint a lawyer for the entire case in the felony case. Everything is on your paperwork. All right, step to your left. Mr. Johnson? Oh my gosh, just stand right here, Mr. Johnson. I forgot. No, there's been this, I have to do electronic warrants when they hit. There's been 2 of, now it's 2 sitting here. I got to do, they're very quick though, so just hang out. Mr. Carlos Johnson. And for purposes of this recording, I'll note that I spoke to Mr. Johnson at the end of the prior calendar, and he did decide to keep his rights, or he didn't decide to waive, let's put it that way. But then I was notified after court that he did want to waive, and so I said I'd put him on my 11 o'clock calendar to find out if he did want to do that. So, Mr. Johnson, do you still want to waive? Do you have any questions you want to nail down? You can tell me, because you still don't have to waive. It's voluntary. If you change your mind between now and then, I'm not mad. I'm just going to send you on your way. You don't have to waive.
That's for the 30 days, right?
Correct.
Yes, I'll sign for it.
All right. Then I need to ask you some formal questions, because when you give up rights, it's a formal procedure. So I have to make sure you understand the rights you have, and then I will ask if you want to give them up and sign the waiver. All right. So did you read the waiver of extradition paperwork? That's the card.
Yeah.
All right, because that's what you'll be signing electronically, and we will give you a copy of what you signed. Do you understand that you do not have to sign waiver paperwork in this case?
Mm-hmm.
I need a yes or no.
Yes.
Okay, thanks. Only if somebody ever transcribes this. All right. Do you understand that you have the right to have an extradition hearing here in Arizona?
Yes.
Do you understand that you have the right to hire a lawyer at your own expense for the extradition proceedings.
Yes.
Do you understand that you have the right to insist that a governor's warrant be signed by the governors of both states before you are returned to Ohio?
Yes.
And do you understand that you have the right to bail if you don't waive extradition?
Yes.
And do you understand that if you do waive extradition, I will order that you be held without bond for 30 days, beginning at the conclusion of any Arizona cases?
Yes.
Okay. Understanding all those rights, do you want to give them up and sign the waiver paperwork?
Yes.
Has anyone threatened you or promised you anything to get you to sign this paperwork?
No.
And have you had any drugs, alcohol, or medication within the last 24 hours?
No.
All right, then I find that you knowingly, intelligently, and voluntarily are signing the waiver paperwork and waiving your right to an extradition hearing in this case. My orders will direct our sheriff's office to notify Ohio that you're ready to return. Ohio will have 30 calendar days to come and get you, beginning at the conclusion of any Arizona charges or holds. We call that local cases, but it really does mean all of Arizona. Any questions for me before we finish?
No, no.
All right. So if you step over here, my clerk's going to have you sign electronically a couple of times. She'll give you copies of that. We may need to live sign it if it gets too weird.